Morning, I'm Joanne, and I'm going to be talking today with my colleague Hannah Moran about GDPR issues for the education sector. So you'll see our details on the next slide. So I'm a partner in the commercial team, and I've been advising on data protection issues for more than 20 years, so way before anybody was at all interested in them. And I normally say that I have been advising on three different regimes relating to data protection. But as of yesterday, it will soon be four. So yesterday, the Data Protection and Digital Information Bill number 2, and the number 2 is in the title, was introduced into Parliament. So the UK is reforming its data protection laws and regime again. So we've not had time to fully digest it for today, but we are looking at some key issues later. And certainly there are some things that we're going to be talking about where it might impact. Now, obviously, because it's just a bill, we don't know exactly what it's going to end up looking like. But I think the majority of it will probably be very similar in view of the ability for the government to push things through Parliament. So as I say, I'm going to be presenting with my colleague Hannah Moran, and Hannah is a solicitor in my team who also specialises in data protection issues. So what are we going to cover today? Let's looking on the next slide. So we are going to have a look at some stuff that is very much hot off the press. And I think one thing that you can definitely say about data protection is that it's fast moving. There's a lot of change, and a lot of the things that we're going to be talking about, as I say, you've got the reform that happened yesterday. You've also got this guidance from the Department for Education, and that was issued in February. So a lot of it is very, very recent. We're also going to be having a look at what the ICO is interested in from an enforcement point of view, and that's in ICO 25, and that came out. That's their strategy going forward, and that was towards the end of last year. We're going to have a look at what fines have been issued and for what, and in particular, have a look at some fines in the education space. And then, as I say, finally, we're going to have a look at the data protection reform. So starting with the guidance that came out by the Department for Education. So who does it apply to? Moving on to the next slide. It was published on the 3rd of February, and it says that it applies to schools and also maths. It doesn't then define what it means by school. It doesn't make it very clear as to whether or not it automatically extends to things like colleges or independent schools. But I think even if you don't fall directly within exactly what it says, I think there's a lot of really useful information in there, and you can certainly extrapolate if you are in an independent school or within a college. Some of them are more relevant to schools, some of the provisions, because they relate to younger children than for colleges, but certainly I think a lot of it will be applicable to the education sector as a whole. We've put a link there on the slide to the guidance itself, if anybody is interested in looking at it. It's been broken down into bite-sized chunks, and you'll see the sorts of things that it covers on the slide. It's also quite, it's written in quite an accessible way as well, so it's not overly legalistic, so it is worth a read for anybody that's interested and hasn't already had a look at it. It covers all the key things, as you can see. It goes through things like the lawful basis for using personal data, what responsibilities should be within schools. It looks at what the role of a data protection officer is. It looks at data breach. It looks at DSARs. So all of the key things that you would expect guidance to cover, and also presumably, certainly from our experience in terms of advice that we give to schools, the sorts of things that we come across on a regular basis. So what we've done is we've picked out some of the key topics, and if we move on to the next slide, we're going to start by looking at roles and responsibilities. So you'll see on the next slide, it breaks it down in terms of what it sees the responsibilities of governors and trustees are, the senior leadership team, and also general staff. And what it does, it then sort of makes it clear what it thinks from each tier is that their sort of scope of responsibility is. So you'll see in relation to governors, their position is more of an oversight position to make sure that essentially the school is doing what it should be doing. So they have a look at, they support the DPO, they make sure that appropriate policies and procedures are in place and things like that. So it is an oversight role. So senior leaders, essentially, they make a lot of the decisions. So they'll make decisions about what technology should be used, what security provisions should be there in conjunction with the security manager. They'll also decide what data is collected and how it's shared. One of the things that the guidance is very clear about is that where you've got data sharing, it needs looking at quite carefully, and also that appropriate contracts are in place. It then sets out the obligations of the various staff, and I think it's worth bearing in mind that from a staff point of view, it does regard staff as a whole as being relevant from a data protection compliance point of view. So it's not just teaching staff, they're very clear that it should extend to catering staff, welfare supervisors, library staff, cleaners, volunteers, etc. So I think it's worth bearing in mind that whenever any training is rolled out, or whenever any policies and procedures are rolled out, that they do need to be communicated and all staff need to be brought in and understand what their obligations are. It also makes it clear that if you've got staff with a particular data protection role, then as you would expect, they've got more obligations to understand what has to happen from a data protection point of view. So, if you've got staff who are involved in data collection or data crunching or anything of that nature, then they have more obligations to understand what they need to do. So moving on to the next slide. Now, one of the things that is interesting in the guidance is that it also looks at the types of data that a school might process. So I'm sure that you're all aware that there are two types of personal data. Essentially, you've got ordinary personal data and you've got special category personal data. And special category personal data is the more sensitive type of personal data, and it is set out in Article 9 of UK GDPR. And you'll see on the slide the sorts of things that it will cover, such as racial or ethnic origin, religion, political opinions, and things of that nature. Now, the guidance also has a section that makes it clear that it considers it's best practice to treat additional types of information as special category data. Now, if you have a look at the sort of data that we're talking about, so as you'll see on the slide at the bottom, it's safeguarding issues, people in receipt of so pupils in receipt of a pupil premium, those with special educational needs or disability, children in need, and those who are essentially in care with a local authority. Now, some of those things will already fit within the definition of special category data. So obviously disability will fit within health data, and health and mental health data is already within the Article 9 category of special category data. Some of the others, though, don't automatically fit within some of the Article 9 list of things that are special category data. So I think it's worth bearing in mind, and it doesn't say you have to treat it as special category data in terms of these additional things, but it says it's best practice, and I think it would be wise to do so if the guidance is out there in terms of that this is what should be looked at. So it does sort of expand upon what actually comprises special category data from a school point of view. And as you may well know, if it falls within special category data, then it will have to be handled with kid gloves, essentially. So there are rules about when you can use it. So with special category data, not only do you need a lawful basis under Article 6 of UK GDPR, but you also need a condition under Article 9, and sometimes it also pings you into the Data Protection Act 2018. Also, if you have a data breach, which involves special category data, then it will be taken much more seriously by the ICO. So expanding the list of what should be treated as special category data does mean that in terms of the compliance burden is expanded in relation to these additional categories of personal data. So moving on to the next slide. One of the things that it's very keen on is looking at the use of consent, and it does spend quite a bit of time looking at this. And again, in some respects, it aligns with what the current guidance of the ICO says, and in some respects, it goes further. And I think that's a little bit of a theme with this guidance. And I think somebody's raised a question in relation to photographs, and certainly that is something that I will be looking at. It even gets its own slide in addition to this slide a little bit later, because that is something that we have noticed, is that it does gold plate some of the obligations that the ICO position it currently takes. So the use of consent, it breaks down into three of the main areas that's looked at. As I say, photographs is one of the things, and because it is so important and because we get a lot of questions about photographs, we have given that its own slide. If we have a look at the other two then at this point, so fundraising and marketing. This is an incredibly complex area, and to be honest, I could spend an awful lot of time in the majority of this presentation talking about the nuances of things around that. Here, what it's talking about is essentially email marketing, and the reason it raises email marketing is because there is a difference in the regulation between essentially written marketing that is sent by post or by satchel post or something of that nature, and email marketing, or so email marketing, which most people will use these days, is subject not only to UK GDPR but also to the Privacy and Electronic Communications regulations, which we abbreviate to PECA. Now, in the public sector context, essentially consent has to be used for both fundraising and also in relation to marketing, and this is something that the guidance is quite clear about. There is more latitude in the independent sector, where there is more of a sort of contract and payment, where it is possible that essentially consent doesn't necessarily have to be used, and legitimate interest and a soft opt-in could be used in that situation, although that is only for commercial marketing at the moment, and certainly fundraising, even in the independent sector, would have to be done in relation on the basis of consent, and similarly promotion of aims and ideals. Now, one thing that is worth bearing in mind in relation to this, because it is quite a difficult area, is that the new law that is proposed and was put into Parliament yesterday does propose extending the ability to use legitimate interest and a soft opt-in. So soft opt-in is more of a sort of opt-out rather than an opt-in basis for marketing to the public sector in some respects. So I think it would be useful to sort of drill down into that to see how that might help schools going forward. But at the moment, certainly the guidance that's come out of the DfE is that essentially fundraising and consent, unless you're in the independent sector, should be done on the basis of consent. Data sharing is also one, and they have this comment in the guidance that essentially before any personal data is shared, that consent is usually the basis on which it has to be shared. Now, I would disagree with that in that it is possible to share personal data without consent in a number of respects. And that's certainly something that we're going to have a look at on the next slide. So the guidance, moving on to the next slide, you'll see it says that there are situations where consent is not required in terms of the individual can't give it. It's not reasonable to ask for it, which I think is a bit of an odd one. I'm not really sure what that aligns to, and also where there's a safeguarding concern. The position of the ICO is essentially where you're sharing personal data, you need a lawful basis to do it. And you look at the type of personal data, and you have a look to see what the lawful basis will be. Now, it's not always going to be consent. There are a number of other ones in Article 6, so it might be public task, it might be necessary for compliance with law, etc. Equally in Article 9, where you've got special category data, because you remember I said earlier, if you've got special category data, to be able to use it, you need both something from Article 6 and also something from Article 9. Essentially, there are other alternatives. And I think the safeguarding point is a case in point, and obviously they call that out, so you don't need consent for that, and that will fall in one of the other lawful bases quite neatly. But there are also other things that will fall into the the other lawful bases quite neatly. So I think they do say that consent is usually required for data sharing. What I would suggest is that you might want to take a step back where you are carrying out a data sharing to see if you really do need consent, because certainly from my point of view, consent is tricky. We'll have a look at what consent needs to be and who needs to give it in a second. But the one thing that is problematic with consent is, one, you have to jump through a lot of hoops to get it, but also it can be withdrawn. And certainly when we get onto photographs, we have seen situations where people have withdrawn consent to photographs and they've been built into a brochure, or they've been embedded on a website, and then somebody withdraws consent and they want them taken down. So certainly from my point of view, use consent where it's appropriate, but also think, is it actually needed? Could you do it on the basis of something else? And the other thing I would say is, for any data sharing, it's always useful having a look at the ICO data sharing code, and any data sharing should really be done and recorded in writing, even if it's a countersigned letter. Any data sharing really should be pursuant to an arrangement in writing. So moving on to what consent might have to look like. On the next slide, you'll see so who should give consent and what do you have to do to get consent. So in the guidance, what it says from a consent point of view is that essentially where you're seeking consent is it should be taken from a parent or someone with parental responsibility for pupils and students under 13. Any student or pupil over 13 should be the ones that give consent. I think it's helpful that they sort of try and set an age limit, but that age limit is certainly not set in stone from an ICO point of view. And certainly the ICO's position is that essentially it's more nuanced. Once you're outside the realms of what they call information society services, so the online world, consent has to be given by somebody who is able to give consent, so who understands what they're consenting to. And it may well be that someone who is 13, that, for example, might have special educational needs, won't understand what the consent is that you're seeking. I think the other thing that needs to be sort of folded in from a consent point of view is that there are certain categories of people where it's tricky to get consent from, and students and employees are generally regarded as being quite difficult to get consent from. And the reason for that is because there's regarded as being an imbalance in the sort of bargaining power between. So, from an employee, it's hard to get consent unless they genuinely have a free choice to say no, because they're employed, and it's hard to say no to an employer. And similarly, from a student or a pupil, it's sometimes quite difficult because of the relationship with the school. So that also needs to be thought about in the context of consent. So I think it is more nuanced. 13 is a good yardstick. I think you should always be thinking, when someone is 13, should it be them? Should it be the parents? But there are also, as I say, some nuance around it in terms of if, for example, at 13, they wouldn't understand what it was you were asking. It may well be, well, one, you might want to relook at your consent, because that's one of the points that they raise in terms of you need to make sure your consent is clear and accessible. But if it is something that, is not going to be something that they will be able to understand no matter how you frame it, then it is something that you might want to look at from a sort of parental responsibility point of view or parent point of view. I think if you're making a decision not to take a consent direct from someone who is 13 and above, it would be useful to document your reasoning. And the reason I say that is, certainly I would always say, under the UK GDPR regime, not only do you have to do the right thing, but you also have to document the fact you've done the right thing. And I think it's always useful to document your position, because if there's ever a complaint, having a documented reasoning for something, should the ICO come knocking, is useful. And if they see that you've tried to do what you need to do, but maybe they disagree with your reasoning, and they will be more lenient than if there is no indication of why you've done something. So in terms of what consent needs to look like, it has to be freely given. And this is back to the point of having someone that can freely decide whether or not to give it to you. So if there is an imbalance in the relationship, this is why it gets tricky. It has to be granular, so it has to be detailed. It has to be informed and unambiguous. So the consent, in terms of whether the consent is given, you do have to be super clear whether or not the consent is being given. Don't use pre-tick boxes. So pre-tick boxes isn't unambiguous because essentially they might have missed it, so they need to tick the box themselves. It needs to be transparent about what they're agreeing to. So you need to break down in terms of, for example, you know, what the data is, what you're going to do with it, if you're going to share it with somebody else, who you're going to be sharing it with, and how it's going to be shared, for example. The other point that I mentioned earlier about why consent isn't always such a great thing is that you also need to be clear with people how they can withdraw consent. Now, if somebody withdraws consent, it doesn't affect what you've done based on that consent to date. So, for example, if you've got a photographic consent and somebody's given it and you've put them on the website and then they withdraw it, any prior use before that withdrawal is still valid. But it then obviously causes problems going forward in terms of potentially removing the picture from the website. But as I say, we'll have a look at pictures in a minute. Also, the guidance is keen that where you're seeking consent, or potentially where you've got a reply slip with parents and you're collecting personal data, is that you include a link to a privacy notice. And the final point, which is I would echo, and it is in the DfE guidance, is essentially if you are getting consent from a pupil, make sure you are very, very clear. Any communications with pupils and students needs to be written in a way that they understand it and is accessible for their understanding and age level. And one of the things that they suggest, not necessarily in relation to consent, but with communications about things like privacy notices and things like that, is that you might want to look at using images or cartoons and things like that with younger pupils to explain what it is that's happening. So moving on to the next slide is photos. So we've had a question to say, thought that the ICO guidance was more relaxed, and it is. So the DfE guidance says that consent is required for any use of a photograph, both for staff and for students or pupils. And whether or not you're putting it on social media, or whether it's in marketing material and things like that. Now, there is ICO guidance on photographic consents, and it is less restrictive than this. And certainly I've also spoken at an event where a representative from the ICO was speaking, and they were also clear that consent wasn't necessary in all situations. So the guidance and the ICO at that conference was very clear that it's possible in some situations where it's relevant to use legitimate interests. So there are situations where you might want to think about not getting consent. So, you know, if it's a big group scene or something like that, or, you know, maybe a sports match at a distance and you've not got names on the backs of the players or anything of that nature, then it might be appropriate for legitimate interest. But as I say, this guidance has sort of pulled away from that and has gold-plated what the ICO says, and says you do need to get consent. It'll be interesting, as I say, with the new sort of law that's coming in, which is meant to be sort of relaxing the red tape and things, whether they still take this approach sort of going forward. The other thing that the DfE say is that you can't include the name of a pupil on any photograph without consent. And I think certainly if you are including names, you need consent from a photograph point of view. I think legitimate interest would be very difficult to make fly where you're essentially including names. And they also make it clear that their view is that if there is identity management systems at school, then you know, once say a pupil and presumably a member of staff has left, then they should be deleted from the system. So photographs is a perennial difficulty for schools. I am aware of that, and we do regularly give advice on where the line is drawn between consent and legitimate interest. And as I say, this is one of a number of areas where the DfE guidance does try and take quite a strict approach and gold plate the ICO's position. Moving on to the next slide, something that is quite useful, and we have been asked about this before, is about publishing exam results. So they are clear that consent is not required in order to publish exam results. But what they do say is that essentially you should forewarn people that results will be published and where they'll be published. And if anybody objects, then you will need to remove them from the list if they ask for that to happen. So that is quite helpful clarification. Moving on, one of the next things that they deal with in the guidance is in relation to a data protection officer. Certainly, there is a very clear obligation under UK GDPR that a public sector body is required to have a DPO, and public sector is generally regarded as any organisation or entity that is subject to FOI. So essentially maintained schools, academies, colleges will need a DPO. In the private sector, there's a bit more latitude, and you'll see on the slide the situations where a DPO is needed from a private sector point of view, but certainly even in the independent sector, I'm aware that a lot of schools do have a DPO. The guidance makes it very clear that in its view, schools and MATs must have a DPO. They are quite helpful in the guidance by making it clear that you can share a DPO, you can share resources. So if you've got a MAT, then essentially, you know, you can share across the schools, you potentially can collaborate, and similarly, schools can share a DPO. Currently, there is a requirement that a DPO is independent. So the person that is the DPO can combine their role as DPO with another role within the school, but it has to be a role that doesn't compromise their independence as DPO. So as DPO, they are there to make sure that what is happening aligns with data protection laws. They should have an ability to go to the highest management level to raise any concerns that they have. So because they have got that oversight role, the role that they combine it with shouldn't be one that is making decisions about how data is collected and what it's used for. So essentially, a DPO shouldn't be marking their own homework. So if they are, for example, an HR, head of HR, or marketing manager or IT director, because they're making decisions around the types of data that's collected, how it's used, what happens with it, they can't then put their DPO hat on and go, yep, that looks perfectly fine, perfectly compliant. So that is something to bear in mind at the moment. Now, DPOs are something that are considered in the new bill, and DPOs are going. So there will not be DPOs going forward, but there will be these things called SRIs. So essentially senior responsible individuals. Now, I don't know whether it's just a change of sort of acronym, whether there's more to it. It is made clear in the new bill that essentially you can combine with other roles. There has been some discussion about whether or not the bill will also relax the independence requirement, and that's something that we'll be having a look at in the coming days. As I say, the bill landed yesterday and is 200 and odd pages, so we've not ploughed our way through it completely. As I say, we've highlighted some key issues later, but this is something that is probably worth monitoring in relation to the DPO requirement as to whether or not the position will be relaxed going forward. Moving on to the next slide, and we're getting towards the end of the guidance, and I'll be handing over to Hannah in a moment in relation to looking at enforcement action. DPIAs. for those of you, I'm sure that a lot of you are aware that a DPIA is essentially a risk assessment that looks at a new or changed type of use of personal data. Now, we do see essentially people that try and avoid doing DPIAs because they don't like doing them because they're quite long. But in actual fact, they're a very useful tool, and I would actually say embrace a DPIA if you've got any concerns about the processing or some new technology that you're buying and how it might use personal data, or some data sharing you might be doing that you're not really sure whether or not you think it all sort of hits all the right bits from a data protection point of view. And certainly what the DfE guidance says is that essentially you should do a DPIA where you are doing any processing, so any new processing that you might be starting or change processing that affects vulnerable data subjects. And vulnerable data subjects are expressly stated to include children and employees. Now, again, this does gold plate what the ICO requires, because there is a list on the ICO website of when you need to do a DPIA. And generally, they say that on some of the list, and where the vulnerable individuals list appears, is that you should be looking for 2 risk issues to trigger a DPIA. Now, this is just one, so it does go above and beyond what the ICO is currently requiring, but this is what the DfE guidance is saying. And certainly from my point of view, I would say, you know, we see, we advise on DPIAs and whether or not DPIAs should be done. And just because there's a processing relating to employees of itself, without there being anything else, so, you know, without it being maybe biometric entry controls or something like that, so it's just employees, we wouldn't normally expect a DPIA to be done in relation to that. But nonetheless, it is in the guidance. The other thing that they're saying where a DPIA needs to be done is in relation to use of biometrics, AI, Internet of Things, safeguarding equipment. And I think I would echo that if you're moving into this new sort of technology, it would be wise to do it. And certainly one of the things that has got a school into difficulties with the ICO, which Hannah will have a look at soon, is facial recognition technology. And it is very popular, but it does need quite careful thought, and a DPIA will be needed. One thing to bear in mind is in relation to the template, the ICO does have a template. You don't have to follow it, but obviously if you follow it, you can't really be wrong for using the ICO template. And also, essentially, you don't have to demonstrate that you, as I've said on the slide, you don't have to eliminate all the risks, but you do have to show that risks are mitigated to an extent that means you are still compliant with data protection laws. So the final thing I'm going to have a look at before I hand over to Hannah are subject access requests. And again, we come across subject access requests a lot. They're quite difficult for schools for the reasons that I'll have a look at in a second. And certainly I could and have spent a whole session on data subject access requests and the difficulties relating to DSARs. The difficulty that we see with schools a lot is trying to work out who the right person to make the DSAR is. So obviously you have the pupil, and quite often you have the DSAR made by the parent and sometimes by solicitors who've been engaged by the parent. And it's a question of should a parent be the one to make the DSAR, or is it the student or pupil that should be making the DSAR? And this comes back to the point we were talking about before in terms of consent, and is a student old enough to understand the need, you know, what a DSAR is and what they're going to be getting back as a result of the DSAR, and will they be able to understand it? Now, obviously, it's not an issue for colleges because of the age of students within colleges, but certainly for schools, it is a perennial issue. And again, the guidance is basically saying that once you get to 13, it should be the student or pupil that makes the DSAR. That is, as I said, in relation to consent, quite tricky, because the ICO position is that you have a look at the understanding of the pupil, as I said earlier, and it's not always the case that it's appropriate for the 13-year-old to do it. But I think it is an analysis that needs to be done. And as I said earlier, if you are not going to require either the pupil to make the DSAR themselves or to give consent to the parent or the solicitor if they are 13, document why you've made that decision, why you don't think that the pupil has the understanding that you need to be able to do it. As I say, I think it's quite useful because it sort of sets a sort of bar, but it isn't one size fits all, and I think it is more difficult than the guidance would indicate. One thing I will just flag is that we have got a module in our Back to Basics range on DSARs, which looks through what you have to do from a DSAR point of view, but also the common issues in terms of what sort of authority do you need from solicitors, what should you be getting if a third party is making the DSAR, when can you pause time, etc. Now, the other thing I will entirely hold my hands up about is that yesterday slightly scuppered things in that there is in the bill there are changes to DSARs, not fundamental changes, but there are some changes to DSARs. So if anybody is interested in the module and does buy it, then we will update it and provide you with the update once the bill has become the Act and we know exactly what's happening from a DSAR point of view. But nonetheless, the majority of it will remain unchanged by the Act. So now I am going to hand over to Hannah, and she's going to have a look at what the ICO is interested in, what's going to get you into trouble, things you need to think about. So Hannah, take it away.
Thanks, Joanne. So as Joanne said, I'm going to be taking a quick look at some of the things that the ICO has been interested in and kind of what their strategy is. So moving on to the next slide, please. So the ICO has launched their ICO 25, which sets out its strategic objectives for the next 3 years. And as part of this, they've set out an annual action plan, which runs from October last year to October this year. Some of their strategic objectives you'll see are set out on the slide there, but in particular, they're looking at things such as safeguarding and empowering the public, particularly the most vulnerable in society, with a particular focus on children's privacy, AI-driven discrimination, so things like biometric technology, online tracking, CCTV, things like that, direct marketing and DSARs. In September 2022, the ICO issued TikTok with a notice of intent for a £27 million fine due to its failure to protect children's privacy. So John Edwards, who's the Information Commissioner in the UK, said that the use of children's data is a key focus, and the ICO will be investigating companies which aren't conforming with the UK's Children Code and are not looking after children's data privacy. Another thing that the ICO are going to be looking at is about taking enforcement action, and they'll be taking enforcement action where it's necessary to make a real difference in people's lives. So as part of this, over the next 2 years, they'll be trialling a revised approach to public sector fines. So in practice, this will mean an increased use of the ICO's wider powers, including warnings, reprimands and enforcement notices, but they have said that fines will only be issued in the most serious cases because they don't want to divert money away from the public sector where it's needed most. And then finally, they're also going to be looking at promoting openness and transparency. So the emphasis is on public sector organisations and what they should and could make public. So the ICO will be publishing statistics and information on all FOI cases and decisions made, and other things that they've taken action on to help clarify the regulatory approach. The publication of reprimands from Q1 last year onwards will also increase any potential litigation risk exposure and reputation damage for organisations which are subject to such reprimands, because they'll be out there in the public sphere. So if people want to take a look at those data sets and potentially put a claim in for compensation or bring a claim elsewhere, then they do have the powers to do that. The Commissioner, John Edwards, did sum up why they made this change. His reasoning was that whatever regulatory action they take, whether it's a reprimand or a fine, its value goes far beyond that individual organisation, and other organisations can learn from the action that's taken by the ICO. So every regulatory action must be a lesson learned by the rest of the economy and play a role in that behaviour change. So moving on to the next slide, please. So the ICO, in terms of their enforcement strategy, have issued a blog recently which kind of sets out what they tend to look at before they issue a fine. So they've set out why fines happen and how organisations can avoid these. So the top things are the things set out on the slide, so such as being irresponsible with people's data, so not taking adequate security measures, and then cyber attacks or other personal data breaches happen. Organisations seeing data protection as a one-time exercise. So it's about looking at what your data protection practices are, if they change, making changes to reflect those changes that are happening, and keeping up to date with the things that are happening in terms of legislatively, like with the new data reform bill, or in terms of other things like good practice guidance and things that the ICO are always publishing and developing. Another one is getting caught out by PECA. So as Joanne mentioned, this is marketing and electronic communications and things. So if you're kind of doing any fundraising or marketing, making sure that you are looking at PECA, making sure that you're complying with that, as well as considering any data protection aspects. And the final one is waiting until something goes wrong before actually taking any action. So if something does go wrong, the ICO will often look at what measures have been taken to mitigate any risks to individuals and people's personal data. And if nothing's been done to kind of mitigate any risks, or you've just kind of waited until things go wrong and it can't be fixed, then it's probably not going to look very well in the eyes of the ICO. And at that point, they probably would look to issue a fine rather than take some other enforcement action. So moving on to the next slide. As Joanne mentioned, there's been a focus on facial recognition technology, and the North Ayrshire Council case really highlighted that recently. But before we look at that, facial recognition technology, it's been a topic for data protection authorities across Europe since GDPR came into force. So it's not something new, but it's something that is being developed more, and there's a spotlight being shined on it more now. So in other areas, the Swedish Data Protection Authority fined a school 200,000 Swedish krona for creating a facial recognition programme in violation of the GDPR. This was because although they obtained consent from students and parents to collect sensitive personal data, there was a significant imbalance between the students and the school, so consent wasn't deemed to be freely given. It was also noted that the school processed more personal data than was necessary for the purposes which they said they were going to use the facial recognition technology for. They also used it to determine whether students attended classes, which they didn't communicate to students and their parents when obtaining that consent from them. So in the North Ayrshire Council case, they were using they considered using facial recognition technology to verify pupils' identities at the cash register during lunch to make it a cashless catering programme. It involved processing pupil special category data, so biometric data, and concerns were raised, which led to an inquiry by the ICO into the processing that was being considered. And the letter published by the ICO provides some useful guidance and lessons that can be learned if you did want to bring in facial recognition technology or something similar into school or college. So the first point was about consent. So as Joanne said, you need a valid lawful basis to be able to process any personal data. And on top of that, you need an additional condition to process any special category data. So consent and explicit consent are likely to be the most appropriate for things such as cashless payment, but there might be other grounds that could be used for other technologies or other processing. So it's always something good to bear in mind. If you are going to rely on consent, as Joanne's said earlier on in the presentation, it must be freely given. So pupils or students must be able to say no without suffering any detriment or negative impact. So if they say that they don't want to provide their consent to this processing, an alternative system must be provided. So access to the same catering options must be provided by using a physical cash register or something like that. Moving on to the next slide, please. The second point that was raised was about transparency. So in the North Ayrshire case, the privacy notice didn't fully explain to children in child-friendly terms the potential impacts and complexity of the processing of biometric data. So this didn't allow the children to be able to make an informed decision about what personal data they wanted to share. They weren't clear about what happened to their personal data, and ultimately they couldn't decide whether they wanted to exercise their data protection rights or not. Also in terms of retention, so the retention period wasn't specific in the privacy notice and didn't address the retention period for the various elements of the personal data that was being processed. In terms of contracts, so often you will probably be using a third-party provider to provide that facial recognition technology, and a compliant contract needs to be in place between you, the school or the college, and the provider of that technology in order for that processing to be lawful. So there needs to be an Article 28 compliant contract in place. But if there's any data being exported or transferred outside of the UK, then there might need to be appropriate export clauses included in that contract also. And the UK does have their own international data transfer agreement, which might need to be put in place alongside a transfer risk assessment, which is what is needed if there's any export of personal data. Finally, back to DPIAs, one must be completed where biometric data is involved, and especially where it's children's biometric data. So you must ensure that the risk of bias and any discrimination in the use of the facial recognition technology is identified, assessed and mitigated when you're doing that DPIA even. finally, moving on to the next slide, just quickly about what fines have been seen. So there's been a number of fines recently for different things. A lot of them centre around marketing and there not being appropriate consent being in place, and also data breaches resulting from cyber attacks and things. But looking at a couple of the few at the bottom on the slide, which are really appropriate to schools and colleges. So the Belgian School Board was fined for the unlawful processing of personal data for children under 13. So they didn't obtain any parental consent for processing that special for that personal data, and they were fined €2,000 for that. And the one at the bottom, the head teacher, he was fined personally £1,099 because he uploaded sensitive personal data from the 2 previous schools he worked at onto the primary school server that he was now the head teacher of. He didn't offer a valid explanation for why that information was uploaded, so he was fined £700 by the ICO and ordered to pay an additional £364 and 8 pence in costs and a victim surcharge of £35. So that was a personal fine for him in his role as a head teacher. That's all from me. So just to finish off, I'm just going to pass back to Joanne briefly to talk about the data protection laws and the reform that we've seen recently in the UK.
Thanks, Hannah. So moving on onto the one after the picture, the data reform bill. So I've already sort of trailed it in terms of it was put into Parliament yesterday. It builds upon a bill that had already been in Parliament and was withdrawn by the short-lived Liz Truss government. It essentially positions itself as a common sense-led UK version of EU GDPR. So it sort of wants to be business friendly, it wants to be research friendly. Some of the rhetoric that came out in relation to the original bill was that we were taking back control of our data. I think that's been dialed down a bit in relation to this, and it is more positioned as being helpful to organisations and business in terms of cutting back on red tape. It is quite long. We do need to go through it in detail, but some of the key issues that we see is the idea is that where you're able to use legitimate interest as a lawful basis, and I know there are issues for public sector bodies with legitimate interests, but where it is available, that there will be a list of those uses of personal data that will potentially fall within legitimate interests and that complicated legitimate interest assessments won't be needed. Equally, there'll be clarification of where data can be used without consent. You can, as one of the points that I made when we were talking about consent in the context of fundraising and marketing, is that it does extend the ability to use the soft opt-in, so essentially an opt-out, to the sort of charitable, public, non-commercial sector. So that is quite useful from that point of view. Essentially, it's where people have expressed an interest rather than where they've contracted with you, which is what it is in the commercial context. We've talked about the fact that a DPO will become an SRI. It'll be interesting to see quite how that happens, and equally the DPIA will be changed, but again there'll still be an obligation to carry out a risk assessment in relation to high risk processing. So whether they're changes, as I said during earlier when we were talking about it, whether they're just changing acronyms or whether there are more substantive changes, it will be interesting to see. And also it'll be interesting to see the guidance that comes with this, to see what it will say around it. One of the issues in relation to DSARs, which is interesting, and one of the things that we do see people querying a lot, is what's meant by manifestly unfounded. If a DSAR is manifestly unfounded or manifestly excessive, then it can be refused. And that wording is being changed to vexatious in relation to manifestly unfounded, and the scope of what's vexatious has been put into the bill. So that will be something that will impact upon DSARs if that goes through. The other thing, which I don't know how useful it will be, basically most businesses and organisations are required to have a record of processing activities unless they're very small and don't process special category data. That will be done away with apart from for high-risk businesses. The reason why I'm not sure how useful it is to businesses is that putting together the record is quite useful to flush out what you're doing with the data, and also to enable people to write things like privacy notices and things like that. But nonetheless, that is one of the things that they've put forward as minimising red tape. There will be other things, but they're certainly the key things that they've been emphasising as being one of the the successes of the new bill. The other thing is that they are expanding upon when data can be used from a research point of view as well, and that'll be quite interesting to see how that pans out. The bill itself, I wouldn't suggest anybody pulls it off and has a look at it, because, as I said earlier, essentially it's one of those bills that sort of changes particular words. So it will change, for example, one of the provisions is it says replace manifestly unfounded for vexatious, so it is quite hard to read. There will be something that will be produced where essentially it will be integrated within the legislation, so it will make it much easier to read. So I'd wait for that if you're planning on having a look at it. And also, it's not written in stone. It has to go through Parliament, obviously, so it might change, but certainly that's the flavour of what it's saying at the moment. So hopefully it gives you a heads up, and certainly we'll be looking at it in more detail in the future, and communicating about what it's actually going to mean when we've got more information about it. So that's the end of what we wanted to talk about today. If anybody's got any questions, we have had another question in about whether or not a primary school needs consent to share pupil data with a prospective secondary school. I think one of the things that's relevant in relation to that is that there is an obligation on moving schools to share a pupil record in its broadest sense, so that may well help you in relation to that, and that doesn't need consent. Obviously, if there is something particularly contentious or there's an objection by parents, it might be something having a look at in detail, but certainly that there is a difference between general data and a pupil record in relation to sharing. So if anybody's got any other questions, then we've got a little bit of time, although I see that we're up against our stop, but equally, if there's anything that you think about later, then our details are on the slide and you can drop us a line, and we'll come back to you. Thanks very much for your time today.